visitation center. Most state prisons, both the male and the female state prisons, through Friends Outside, have visitation centers. For those of you who have visited clients in state prisons, you will see that they're very lovely visitation centers, and there is no preclusion as to age. If you have a female client who is being held in the Linwood facility, the Linwood facility has a program going on right now with Friends Outside. And they have also an excellent visitation center for the women who are incarcerated. So it's just wrong. So what I would do is you make your arguments, and then honestly talk to the attorneys in your firm that attend the Incarcerated Parent Committee, or you yourself can email Judge Downing and say, could this be, you know, at least once a year she's tried to do trainings with the other judges. And this has been a pernicious problem. So if it's coming up again, maybe the judges need a new training on visitation.
And also you can Google, they love to show the visitation center in their online ad at the prison. So Google, I'm serious, Google the prison, print out the picture of the visitation center, and show, you know, submit it to everyone.
You know, and the bottom line is there are hundreds and thousands of incarcerated parents all over California who regularly get to see their children. And our parents should not be deprived of visitation, but for a judge saying, I don't think it's appropriate for a 3-year-old to see a parent, when that exact same 3-year-old is visiting their parent because the parent isn't in the system. So, I mean, you know, this is not a strange thing for the California Department of Corrections. Children visit their parents all the time.
Yeah, and there is no study that shows that there's more disease, you know, caught by children or visiting parents in prison than other children.
That's what they said. That's like.
You got to challenge it.
You got to challenge.
You've got to challenge it on the record.
Yeah.
And that may very well be a writ issue as well. If there's a no visits order made at, I don't know, say disposition, and there's not a sufficient finding for it, that's probably a writ.
Don't let them say that crap on the off the record. Make them say it on the record.
That's right.
Oh, yeah.
So I was just wondering, in the committee, if they've talked at all about DCFS having like a specialized unit to deal with. You know, they have the ones that deal with non-minor defendant, special medical. Like, why don't they have one to deal with incarcerated parents, and that way they could perhaps the workers would actually be trained by them?
There's too
I don't
many.
know if that's anything.
There's too many.
Too many incarcerated parents.
Yeah.
Sometimes they're not incarcerated at the beginning, and then they are incarcerated.
But Emily, you know what's interesting is in other counties that aren't so big, like in Santa Clara County, the workers there do take the children to visit their parents. But again, you're only talking about one facility. I mean, we have people who are incarcerated all over the state, so that's the problem.
So incarcerated parents, the last thing I want to say about them is I think visits are number one, hands down the biggest issue that they have. But additionally, the little takeaway from Monica C. as well is that it is not to be delegated to our parents to secure services at their place of incarceration. It shouldn't be, well, the parent didn't tell me that there was nothing available, or father didn't report what services were available at his facility. That is, when we talked about last time, incumbent upon the social worker to call the facility, see what's available, if they need to submit any sort of referral to the facility, or sometimes if the parent is placed in particular units, they have different access, and those things can be worked out if the prison is aware of the programs that the parent needs to be doing, and if the social worker is actually making the contact with the place of incarceration and securing what services may be necessary. So, I mean, sometimes even they can set up testing. I know it seems weird, but I've had it before, for clients who are incarcerated, but that requires a call from the social worker.
One thing I wanted to mention briefly on that is a lot of times we're seeing clients now that are California state prisoners that are moved out of. My experience has been that when in those private prisons, there are actually more and better services available. So be mindful of that as well, because
It's true.
they actually have access to things like testing sometimes.
And on a side note, and we didn't have a special slide for this, but for deported clients, There are also reasonable services cases on deported clients. The department should be contacting DIF, making sure something's done to ensure that DIF is assisting our clients in, if they're deported to Mexico, assisting our clients in getting reunification services. And if that's not being done and the department knows that our client, that our client has been deported and where they are, that is a reasonable services issue. And 361.5 E also talks about deported clients. So that's another place to look at when it comes to what the department should be doing for clients who have been deported.
And again, that's not on our clients to have to contact DIF. That is the social worker's job. So I've seen it, in fact, just today on a case where they said that father waited forever to contact DIF. And I'm like, well, it's supposed to be your job. Should have contacted them first thing. He's been in Mexico the whole time. So, homelessness?
Yeah.
So I don't think we reprinted out the forms from last time, but we gave everybody the linkages, family reunification, housing support, and moving assistance, fact sheet and information if you came to the last training. I can scan them in and email them to everybody after. I'm sorry you don't have them to look at in front of you right now, but we'll give you a little overview, overload of reasonable services right now. A little overview of the program. It should have been rolled out. What we've been told is that it should have been rolled out to all of the DCFS offices by now in terms of training the linkages assistance.
It's supposed to be rolled out to, I think it's done 7 offices, I don't think they've done.
I thought they said by December 1st they would have it. Okay. It may, you know how they give timelines and they never stick to them, but at this point all of the offices should have been trained, I think, on this program. It applies very specifically. It's a very important program, but it applies very specifically to parents who were receiving CalWORKs benefits prior to the removal of their children. So I'm sure some of you have been practicing for a while now. How many times have you heard a client who says, oh, but I'm going to lose my benefits, I'm going to lose my housing. They have CalWORKs, they have, cash aid, they're getting Section 8 or all these various assistance programs that their children get detained from them, and they say they're going to lose their housing. Well, this linkages program that you need to ask for first thing at detention. So when you pick up a case, I think we should make it a practice to start asking our clients if there's any, well, number one, were they receiving CalWORKs benefits? Because that's going to be your criteria for whether or not they're going to qualify for this. But number two, are they having any issues with housing? Even if they're not, a linkages referral is not a bad idea, because what it's going to allow, and make sure it gets it into the minute order, what it's going to allow is that parents who have had their children removed from their home, who are eligible for reunification services, will be able to receive either 80% of their CalWORKs check still, or the amount due for their rent, whichever is lowest, for 6 months for that period of reunification. They can still sign up for general relief to supplement that income, and it's sort of like how our reunification works. If they're in compliance with their reunification plan, 6 months comes up and they're not ready to have the kids returned yet, there is a chance that the linkages program will continue their assistance past the initial 6-month period up to 12 months to assist these parents. In addition to this, and this is a huge thing, that it's really unfortunate because I think we had the people from DPSS come and talk to a couple people, or quite a handful of people from the legislative committee and at Ladle, and they were saying that they've had this system in place for some time, but I think out of all they only had one person all of last year who...
Yeah, well, right now, I received yesterday a list of all the embedded DPSS workers at each one of the offices. They're going to be the linkage person.
Okay.
I sent them out yesterday to a couple of the social workers. When I go back to the office, I'll send them out to all the social workers so you can make sure that they can call directly to the DPSS worker to talk about this issue.
Okay. Perfect. So, I mean, there's a huge benefit to a number of our clients here if we can get them hooked up with this program, because if the CalWORKs recipient needs to move, they've been in reunification for at least 4 months and they're in compliance with their case plan, they're eligible for a one-time payment of up to $2,000 for housing and $500 for utility assistance. That's a big deal for our clients, and that can oftentimes be the difference between getting your kids back at the 6-month review hearing or being in a place where you're like, I need more FR because I don't have a place for my kids yet, because they're in maybe a friend's, they're couch surfing, or or they're in a tiny little 1-bedroom studio apartment that is not suitable for a child. If they need that, they're getting close to their 6-month reunification time, they need help moving, and they're doing what they're supposed to. This is a really huge thing that we should try to take advantage of.
On a side note, DPSS is trying to set up an office here, so we can refer directly down to
Oh, great.
a person here, a reaching person. So we don't have to, wait, we can get it done right away, assessed. We're going through the bureaucracy right now trying to do that. I think the courts should allow them to do that. It's just their own office trying to sign off.
And the actual linkages program, it says in their qualification, or in their requirements page that I'll send out to everybody, that it's supposed to be done within 30 days of the removal of the child. We talked with them independently, and that 30 days is sort of it's their way of saying they want it to be done as soon as possible, so that we don't have these lapses in parents' funding or assistance. But it's not a hard line, so don't let a social worker drag this out and say, oh, well, it's been more than a month since we removed the child. I can't make the referral. Push and make sure that these referrals are being made first thing at the detention, and if you're not seeing any progress on that, come adjudication, disposition, keep pushing and make sure that there's actually a referral being made.
I refer first to the DPSS worker about this, let them link up in the office with the social worker. I trust them right now more than DCFS.
Are they going to take it directly from us? Because when we talked to them at first, they said that they needed the social worker.
Well, I think they can take
make
it
the
from us and
referral.
talk to the social worker, and
Okay.
they can work it that way.
Okay.
And remember, the issue with homelessness is that this is a reasonable efforts issue, but make sure you're raising it early. There was an unpublished case that, again, unpublished, but raising it at the contested 2-2 is a little too late. So we should be trying to raise this early and often to embed our records to make sure that when we come to that 2-2, if your client has a housing issue, that you have made it clear that that was something the department should be helping them with.
And at the hearing that it comes up, if your client is in substantial, not complete, substantial compliance with the case plan, you don't need a child of 0 to 5 anymore. That pilot is over. It can be any age. And the only obstacle to reunification is housing. Okay. That's an issue you should, if they won't agree to sign the order that we prepared, then set it for hearing, okay? And bring in the social worker. Set up for a reasonable efforts hearing. Cross-examine the social worker about what they did, what they didn't do. They're not housing agents, DCFS, but they're supposed to facilitate housing. Right? And so we've asked for them to be trained. Some of them have been on housing and what kind of housing particular people need and the support services. But of course, they all haven't been trained. So it's one of the things we're kind of grappling with right now. You need to set up for a hearing if they won't sign the order. Okay. You can have your worker in your office call the social worker a couple of weeks before the hearing and discuss with the social worker where is the client with respect to substantial compliance. What do you think? We have this order that says they're in substantial compliance and housing is the only problem. What do you think about recommending in your report a paragraph to that effect? Okay. So our pilot was for 0 to 5. We had 25 families that were identified, and we have now housed 14 of those families. That's 43 kids. These people would not have been housed without the program, okay? Because what happens is this order is signed. That triggers funding. Okay, the children may not be released right away, but this order will go to funding the housing agencies, and then they can start the process of assessing the family for the kind of housing that they need. And so, because generally DPSS or these housing authorities will not fund unless it's a family. So we've kind of worked around that with this order that is going to be home a parent, but we have to get them assessed for this, and they will accept that order to start the funding. Yeah.
How do we follow up with that once we submit the order?
Like, you mean, okay. That's one of the problems I heard today. We're having a meeting today at 2 o'clock. We have 21 families now that have been referred that are over 5, okay, not just 0 to 5. And there's supposed to be something set up with the department about how we can follow up with that. No one's reporting back to us, so we don't have an idea yet. So that issue is that's the front issue today we're going to be talking about. Where is the person, who is the person in the department to respond to us, so we know what's going on with these other 21 families, okay? So we'll see. That's what we're working on right now.
Thank you.
Okay, so this is our sort of last big area when it comes to reasonable services issues, which are mentally ill parents and parents with developmental delays.
You know what, I'm sorry, let me go back one more. On the Y drive, there's a homeless policy. Okay, it's about 2.5-page homeless policy, the steps that you should be doing. There's also the order that's on the Y drive. Okay? So you all should have those with you, or at least be familiar with the policy, and have some of those orders. Okay, so when they come up, you can try to get them signed. Okay. All right, sorry.
Sure, I'll do it for Casey. So, In re Casey is a great case that sort of lays out reasonable services in what I feel is a pretty classic case of a parent with a mental illness. The facts in this case were not in dispute. They are as laid out on the slide. Basically, there was a psychological evaluation. They identified some conditions that interfered with father's ability to address the issues preventing his children return to him. The evaluation recommended further examination to determine the extent to which these conditions might be alleviated through medication, and the department's only attempt to secure a pharmacological evaluation was to send father to this public mental health clinic. The clinic found father did not meet its criteria for treatment. How many times have you gotten those little papers from your clients from Rio Hondo that say the client does not meet the criteria, and that's all they get? And the department made no attempts to secure the evaluation elsewhere or to demonstrate any other avenues available for securing the recommended evaluation. Interestingly, in this case, the department tried to rely upon this statement by the father that he said he wasn't going to take medication, he didn't need medication, he didn't think he needed it, he wouldn't take anything unless the doctor for sure told him so, and he was pretty, as the case reads, pretty difficult, it seems. However, what the court, I think, really astutely pointed out is that although it depends to some degree upon the parent's willingness to participate, you have to take into account that when you're dealing with someone with a mental illness, that perhaps their reluctance to cooperate or their resistance is a product of the condition that they're dealing with. And that might be responsive to medication. So even though father was saying, I'm not going to take medication, I don't need medication, he had never actually gotten assessed and been given a prescription and given the opportunity to take that medication, is what they said. So the department can't just rely on the fact that he said, well, we sent him to this place, he probably gave them false information so he didn't qualify for their criteria, and they didn't give him any medication, and he said he wasn't going to take any anyways, so that's it. The court said they needed to, the department needed to take on more of this burden. The department needed to try finding a different facility that would have helped him to secure his evaluation. I mean, I think the theme of this is not that the department needs to keep referring a mentally ill parent to clinic after clinic after clinic if they keep saying no to them, because a lot of times these evaluations are done upon self-reporting, but one referral to a public mental health clinic where simply the box was checked that they didn't meet the criteria is not enough. They need to actually take some active steps to help them find the proper evaluation so that they can get medication if needed. And that may have required the social worker going with father, the court even intimates. So,
excuse me.
yes.
On that issue, Susanna Preciado is a social worker for Birthsburg. She is really an expert on that. So if any of you or your social workers want to speak with her, I'm sure she will talk to you about how she goes about not waiting for the department to do that, because we all know that's probably not going to happen. And Susanna is really a master at putting those places together with the people that need those services. Okay.
And we talk about Elizabeth R. and we all kind of know Elizabeth R.
Right, and there's a recent case, I don't have the site here because it was published on a completely unrelated issue. The issue that talks about the mentally ill parents' reasonable services is not published at all, but it sort of expands upon In Re Casey to say that it's not just the issue with the pharmacological evaluation. This is the same principles of In Re Casey apply to the initial mental health evaluation for the diagnosis in the first place. So this is not limited to, I wouldn't say that it is limited to simply getting the parent assessed for medication. It's also getting the parent assistance with that initial psychological or psychiatric evaluation, whatever it may be. We don't always get 730s ordered. When 730s are ordered, sometimes it can be a lot easier to get the evaluation in place. When it's just checked off on the case plan, the DISPO case plan, that the parent's supposed to get a mental health evaluation or a psychological or psychiatric evaluation, 90% of the time, probably 99% of the time, these parents have no idea where to go, and they end up going to Rio Hondo Mental Health Clinic or Department of Mental Health, and end up saying, I don't know why I'm here, I was told I needed to get a mental health evaluation, I don't really have a diagnosis, I don't know what's going on, and they get sent away. You don't meet our criteria. So this applies for that initial evaluation as well. The department needs to take some active steps in maybe helping to present the information to these clinics so that they can make the proper diagnosis and evaluation of our clients. That's all I have to say about that.
And let's see. Oh, I already moved it. Developmentally delayed parents. We already talked about Tracy J., which I think is the really great recent case on this. Christina L. is sort of the less great case that just because the parent is disabled, that doesn't excuse them from participating in what the court described was an appropriately tailored case plan. And so apparently the appellate court felt that the parent was, I think it was the mother, was relying on her disability as an excuse not to do her case plan. I don't know. And then we also have Victoria M., and this is an even older case about utilizing regional center, which I think is something that we should be ordering on our case plans to begin with if you have a client that qualifies.
Absolutely. Regional center can be very helpful. They have a lot of hands-on parenting classes and a lot of resources that they can offer to assist any of our developmentally disabled parents.
Well,
and
not any, I mean, the
many
qualifications
of
are,
our, when they qualify.
yeah.
When they qualify for regional center. But we should have them being assessed by the regional center for assistance through the regional center.
Just not in San Bernardino.
No?
Yeah.
Well, oh, too soon.
Way too soon.
Too soon.
Okay, the next slide we have is on RPPs. Remember, if the child's in PPLA and there's no permanent plan, as it were, we can set these for reasonable services on not assessing our client. I've read RPP reports that say FR is terminated, we don't have to work with the parent anymore. But if it's PPLA, they do. So we should be doing that more, especially for these kids that are just in foster care, and our clients are marginal.
And just a note on that, a lot of times county council or the court will tell you need to follow 388. You do not need to follow 388. If the kid's in PPLA, they're mandated to consider return to a parent because it's a more permanent plan.
Right, so it's 366.3F. You just need to cite them to the, and still?
Every time, I've raised this, and every single
Is he
time,
not
they've
reading
all
it?
said, you gotta file a 388.
Emily's so.
He just insists on it, and then it's granted, so it's like.
Right.
Can I ask
Well,
something on that?
the-
I mean, when you embed the record, there's nothing you can do if he's not gonna listen, so you're gonna have to follow 388. But why you want to protect yourself is because I would put on the record, he's shifting the burden at that point.
Right.
And that's clear, so God forbid in the future he denies the 388, at least the appellate court will have the issue that he switched the burden at that point. Because the statutory burden on the RPP is on the department at that point, and by filing the 388, he's placed it on us.
Okay, this is the last slide. Active efforts. Most of you are not working with ICWA cases every day. You may have one though. Be aware that the standard for an ICWA case, the department has to be making active efforts. And active efforts is much more than reasonable services. And actually, as I have just begun working with a lot of ICWA cases, and it is surprising how different active efforts is. The department can provide a lot of efforts if they believe they're legally obligated to do so. And they do a lot more. I have a case where they were flying mom out from Arizona to LA County every other weekend because they believe, right, just giving her checks.
I have a case where they bought the parent a cell phone, or well, a pay-by-the-minute cell phone, but they provided the parent a cell phone so that they could contact them because the parent was...
So,
I mean, they will do amazing things in ICWA cases.
right, when they believe the legal obligation is higher, they will do more. So you can expect more if you have an ICWA case, but it's also interesting to know that the department can service the case really well if they believe they have to.
And then the very, very last slide is just, don't forget the possibility of a 352 continuance. Always a good thing to ask for, and in fact, saw it successfully used by an attorney with a case that was not really an Elizabeth R. case, but it was a regional center client who just needed some more time, was getting into some really, really detailed hands-on parenting, needed about 6 more months of reunification, but we were at, actually, I think it was at almost 20 months at that point, but the court granted a 352 continuance, and hopefully that parent will reunify. So it is possible. Keep fighting the good fight.
Okay, and I know we went over time, so...